Hello and welcome to the new series of Drishti IAS. I am Ritu and today we are going to discuss an important topic of polity, which is sedition. And the title of today's topic is Sedition, Illogical Equation of Government with the State. Before moving to the points of discussion, first of all, we will discuss the previous day MCQ. So what was the previous day MCQ? Which of the following countries does not share the border with Persian Gulf? And your correct answer is Jordan, which is option B. And this topic is important from GS2 perspective. This is the point of discussion. First of all, we will discuss the news. What is sedition? What are the recommendation of Law Commission? The debate around sedition. Is it unconstitutional? Practice question for prelims and mains. So, in the next slide, we will discuss what is the news. So this news has been taken from the Hindu. And what is the news? So currently 22nd Law Commission of India has released its 279th report. And in that report, what happened? That it has retained the section 124A of Indian Penal Code. And what is about 124A of Indian Penal Code? So it talks about the sedition law. So this is the homework question for you, that who is the chair of 22nd Law Commission of India? So you have to answer this in the comment section. Moving ahead. Sedition. So what is sedition we will discuss, and what is history related to it we will discuss in this slide. So sedition is an act of incitement of discontent, rebellion, or any action such as speech or writing against the government. In simple words, that if any action like speech or writing or documenting anything will cause any rebellion or discontent among the masses and which can create disharmony in the society is called as sedition. And with whom this all action should be targeted? So these all action should be targeted against the government. So this is the brief definition of the sedition. And what is the history of sedition? So history of sedition is long back, and its history can be traced from the colonial times. So first time it was incorporated in India in 1870, and under section 124A of Indian Penal Code, which is still ongoing. And what was the purpose of sedition at that time? Because at that time there was a British India, and so many Indians were voicing out against the British regime, and because British were doing injustice with the Indian people, so many people were voicing out and they're expressing their dissent among the government regime. So due to this, and due to silencing all these rebellions, so this is the reason this sedition law has been introduced in the Indian Penal Code. So this is a brief history of Indian Penal Code and the sedition. And there at that time there are two kinds of sedition have been introduced. So one was the case of Bal Gangadhar Tilak, and one was the case of Nirendu Dutt. So what was the difference between these two cases? That in Bal Gangadhar Tilak, the court has said that he has written something which is not apt for the society and which has created discontent among the masses, and they started hating to the British government because he has released two weekly, which is Maratha and Kesari. So due to that he has been sentenced to the sedition law. On the other hand, Nirendu Dutt cases, it has been said that there should be intention behind that, the person is want to create disharmony in the society. So these are the differences between at that time. At that time also it has been implemented in a very vague term, and this time also this topic is very debatable, and many of the terms related to it is in very vague condition. So this is a matter of debate, and we will discuss in the further slide that what is the debate related to the sedition. So what are the recommendation of the Law Commission? So the 22nd Law Commission has been constituted, and you have to answer that who is the chair of the 22nd Law Commission. So what are the recommendation it has recommended, and why there is debate over the recommendations? So the first recommendation is that it has enhanced the punishment for the offence. And what it has used the term, it has used the term national security, and it has said that if any act or if any writing or speech will cause the harm for the national security, then the case will come under the sedition. And it has retained the sedition because many times it has been debated that the sedition law should be abolished. And last year also in 2022 Supreme Court of India has asked from the government that all the cases should be stayed, and there should be no fresh case registered regarding this. So this is the reason the government has said that we will review this sedition law. And after reviewing, this kind of recommendation have come from the 22nd Law Commission. So here we are studying the recommendation. The second recommendation is that this time, what is the minimum imprisonment regarding the sedition? So this is 3 years, but the Law Commission has said that it should be increased to the 7 years. So this is the recommendation by the Law Commission. The third is that it has used a word, a tendency, which is debated among the whole media, that why this word has been used and this term has been not clearly defined. So this is created much furor among the masses, that why this term has been used, and it's also in a vague condition, that what do you mean by tendency? Because it is a matter of judicial interpretation. Many times session court will interpret it in a very different way, high court will interpret in a different way. So in different cases this term will be interpreted, and maybe the whatever the imprisonment and whatever the punishment will be given to the convict will be very different. So there should not be uniformity in this case. So the reason this thing is very debatable. And what is the term it has used? With the tendency to incite violence or cause public disorder. It means that many times it will be taken in a wrong way, and you have to show the proof that this thing has been happened. But in the cases like tendency, here tendency will be judged, not your act. So this is very vague in terms of this. Moving to the next slide. What is the debate around the sedition? First debate is around that it has misused the law. So whatever we have seen that from 2010 onwards, more than 13,000 people have been come under this sedition law. So this is very huge number. On the other hand, in the 2020, according to NCRB report, it has been said that more than 70 cases has been registered each year regarding the sedition. So this cases is rising day by day. On the other hand, the cases is rising day by day, but the conviction is very low. So in this sense, it is abused, because many times the officials abuse this case and they arrest the people in the name of sedition, but their conviction is not up to that. So in this way, this law is misused. The second is the sedition against the government, not the country. So this is a matter of debate, because being a citizen of any country, being a citizen of the India, we have right to dissent or express our disagreement with the government. And expressing the disagreement with the government is not a matter of sedition. But many times we have seen that when people are expressing their discontentment against the government, they are charged with the sedition. So in this way, they are expressing their anger against the government, and we have right to express our anger against the government. So it is not a matter of sedition. We are not creating any disharmony. Merely what you can say, expressing our opinion against the government or against any scheme or against any political leader is not a matter of sedition. But this thing is always misjudged, and many people are convicted or arrested in this case. On this, the third is that blurring the lines between terrorism and free speech. Here we have under Article 19, we have right to freedom of speech and expression. But many times, many political activists, social activists are charged with such cases. For instance, Binayak Sen, who was an Adivasi social activist, has charged with this sedition law in the name that he has owned the Naxal literature. So this is a very false case against any person. So and sometimes these activists were charged in a terrorism case, and they have also charged with the UAPA and things like that. So it should not be confused between the terrorist act and the freedom of speech. If any person is expressing their right in the form of freedom of speech and expression, then that act should not become under the terrorist activities or terrorist speech. So there should be difference, and the government should know this difference, and the judiciary should also know this difference, because there are many false cases coming in the society. The fourth is unworkable recommendation, because whatever the recommendation has been made by the 22nd Law Commission of India, it is unworkable in nature. The first thing is that it has increased the terms of imprisonment, which means earlier it was only 3, but now it is 7. And it has also suggested that there should be a tendency. It means that you should not have to prove that this person has created disharmony. And for this cases like this, what we have to first show that this disruption has been caused because of the speech of that person, the writing of the person. So you have to show the evidences of that disruption or any disharmony. But here the word tendency has diluted this law. On the other hand, by rising the terms of imprisonment, if any person is arrested in the name of what you can say sedition, so earlier it has to only up to 3 years, so his only 3 years will be wasted. But now if it will become 7 years, so his 7 years will be wasted. So these kind of judicial errors should not happen. On the other hand, the Union Law Minister has said that this is only a recommendation, and the recommendation of the Law Commission is not binding on the government. So government will think about that this recommendation should be followed or not. So this thing has been not what you can say followed by the union government. It is still under the process that they will follow this recommendation or not. Moving to the constitutional part, many of the experts and judicial experts, journalists are saying that it is unconstitutional in nature. Why it is unconstitutional is nature? Because it has violated the Article 19 of the Indian Constitution, because Article 19 of the Indian Constitution says that you have right, any person of this country has right to express their opinion regarding anything. So it is not a matter of sedition. So first of all, this is the reason this thing is called as a unconstitutional. The second is that in the Kedarnath judgment, the judiciary had highlighted that you need to show the evidences that this disruption has been caused, and that should be the ideal case. And the other courts are also advised that you have to follow this Kedarnath judgment, which has happened in 1962. But what is happening that this Kedarnath judgment is not followed by many courts. On the other hand, the Kedarnath judgment also did not see the fallacy of the law. It has just said that you have to show the evidences regarding the that is there any disharmony or any rebellion has been caused in the society or not. But it has not questioned the existence of this law, that whether this law should be present or not. So in this way, this whole law is becoming unconstitutional. But it is not the opinion of the Union Government of India, or it is not the opinion of Supreme Court of the India. Many experts are saying that it is unconstitutional in nature. On the other hand, many experts are also saying that if this law would be modified, then it will become constitutional and it is more acceptable. So this is also a matter of debate, that this law should be repealed or modified. But many experts are saying that the countries like Ghana, Nigeria, Ireland, Australia has either they have modified or diluted this law, or many countries have also repealed this law. So India should also repeal this law in order to maintain the democratic structure of this country, in order to maintain the freedom of speech and expression. So in this way, many experts are also saying that this should be repealed. But we will think in the future that whether this should be repealed or not. But right now it's there in the Indian Penal Code, and many people are convicted in this case. Moving to the next slide, which is practice question for prelims. So your question is, consider the following statement regarding the sedition. Your first statement is, it is a crime under section 124A of the Indian Penal Code. The second statement is, it has been carried out from the colonial times. The third is, the minimum punishment under this law is given for 7 years of imprisonment. How many of the statements given above are correct? Here you have to follow the instruction of the question. They are asking correct. Your options are only 1, only 2, all 3, none. You have to answer this in the comment section. Moving to the mains part. So your question is, repealing or modifying the law on sedition can positively impact the future of decent and free speech in the country. You have to comment this. You have to also follow the instruction of the mains question. Sometimes they ask critically examine, sometimes they add comment, sometimes they ask discuss with reasons. So you have to follow this thing. So first of all, what they are asking, the law of sedition. So you have to divide your answer in three parts. First intro part, second main part, and third is conclusion. So first of all, you have to define the law of sedition, and you have to give brief intro of sedition, that what is sedition and what is the law related to it in India. And then you have to think upon the demand of the question. What is the demand of the question? The demand of the question is repealing or modifying the law can positively impact the future of dissent. So you have to comment. So first of all, you have to divide your mains thing in two parts, that whether it will positively impact or whether it will negatively impact. So first of all, you have to decide that how repealing could positively impact, and then how modifying could positively impact. So you have to take case studies of various countries who had repealed this law. So you have to show the good examples that how repealing this law has benefited that country. On the other hand, you have to take the example of modifying a law, and you have to also cite few cases that how modification and dilution of few laws have positively impacted the society. So you have to follow. And the second thing, you have to also take care of the how it will negatively impact. It means if we can repeal this law, then people will become free. And here freedom has been given in this country, but it is always comes with the reason. And there is also a restriction on the freedom, that whatever you are expressing, it should not harm the national security, it should not harm the harmony of the society. So if it will be suddenly removed, then it may dismantle the harmony of the society, or it may give extra power to the citizen that they can voice out anything whatever they want. So it should not be arbitrary in the nature. So you have to write this in the main section, and in the conclusion you have to show the way forward, that India should dilute this case, because many times we have seen the false cases, and many people are dying in the jail, they are surviving in the jail because they are arrested in the false case. So these kind of things should be avoided. On the other hand, whatever the problems happen on the arrest part, so the officials should be careful that whatever they are arresting, and whomever they are arresting, it should be a true case. They have to inquire about the case, that the person we are arresting is a right person to be arrested, because many times false cases lead to the what you can say negative impact on the judiciary also, and it will also increase the burden of judicial cases. So these kind of things should be avoided. A PIL should be filed. The rights of all the arrested persons should be taken care of, because many times these persons are not even heard. So these kind of things should be there. So your conclusion into should be in this manner. I hope you like this lecture. If you have any queries related to this lecture, kindly ask in the comment section. Thank you.